Hi, everybody. My name is Shelley. I'm the Advocacy and Membership Manager of Eurocham. While we wait for people to come in, I will already start to give a very short introduction and some administrative announcements. So as you can see, the webinar will be recorded, and we would ask you to not take any photography or screenshots or recordings of this presentation. If you're interested to have the presentation afterwards, you can always contact Eurocham and we can provide you with the presentation. Besides that, I would like to welcome everybody, and I would also like to thank all our panelists, our keynote speaker specifically, and I would also like to share this with you. It's an QR code because Eurocham is also running an AI program. In general, AI in IP is one segment of this. In the AI program, we also have a survey. It's only 10 multiple choice questions and it will only take 5 minutes. So we would like to ask if you're interested, you can scan the QR code. You can also find it on our website and to just take the survey. It's I know everybody always say it's only 5 to 10 minutes, but it really is with this time. So thank you in advance if you have done this. Then I would also like to mention that besides the AI program, Eurocham is also running the sustainability program, and we will have our flagship event on the 5th of November. It's a sustainability awards. There's still time to book a table, so everybody is very welcome to our flagship event as well. I would like to mention that this webinar is organized together with the Southeast Asia IP SME Helpdesk. I would like to thank them for helping to organize this webinar and bringing the panelists together. And I would also like to say that if you are an SME and you have questions on a specific topic of IP, you can always contact them through expert@seaiphelpdesk.eu, and you will get an answer within 3 working days. You can also find more information on their website, of course. And then I would like to give the floor and the real opening remarks to Mary. Mary is the chair of our IPR committee. And Mary, there you go.
Yeah, thank you. Thank you, Sherry. So let me introduce myself. My name is Mary Cho. I'm based in Singapore. So I'm currently actually the chairman of the chairlady of the IPR committee of the Eurocham Singapore. I had a full-time job, so I'm working in Caring, one of the French company. So I work in the intellectual property department and cover worldwide matters. So I would like to actually, first of all, extend you a warm welcome to all the participants, and also thank you for all the speakers, and also Daniel being our moderator for as a part of the moderation. So I would like to throw some background introduction about this topic. So I'm very sure actually AI is no one actually doesn't actually really know. Everyone is actually familiar with actually this term because it's so much actually talk about a hot topic nowadays in every aspect of our life, particularly the ChatGPT. So it's a lot of application. But thinking back, actually a step ahead. Like if you think about use of AI, it's also part of the technology. And how does actually the technology relate to intellectual property? And how does actually intellectual property relate to your business? So this is the first question you need to think about. So intellectual property is actually a very important part of your business, help you to generate business, help you to secure your asset. So the next actually 1.5 hours would be actually, hopefully would be a very actually good brainstorming for ideas, and you guys have some takeaway actually back to your business. So before actually the other speakers start, I would also like to share some ideas. So in your business, okay, when you think about IP, so traditionally we are actually talking about what are your potential IP rights that generate from your business, okay? So we had several types of traditional IP right. So we had trademark, we had designs, we had patent, if you belong to the tech company, and we also had copyright. So think about how actually the use of the artificial intelligence nowadays, think about the application, how they're going to impact 3 areas of your intellectual property. So number one is the generation of your IP rights. So what is the role of the AI technology like change the way your asset, your IP right is generated? Will it still be recognized by the law that it is formally a type of IP right that you can actually have exclusive use as well as entitled to protection? So this is one important question you can actually think about. And second thing is, after you have your IP right, how can you use it? Okay, and important part of the area is not only used by yourself as the owner, but also the opportunity to license it to third party to use it and generate profit for your company. Okay, and the last part is about the protection. Okay, of course, anyone, particularly we have some owners of business here. When you own the IP right, okay, you own the right, you use it. When someone uses your right, how are you going to protect it? Okay, is the existing framework giving us sufficient basis to go after those who copy your business, who actually take away your profit because of the unauthorized use of this? So these are all important areas actually that could be actually coming out from this topic. So hopefully we will get actually some inspiration from our speakers today. So I wish you enjoy this section. Okay, thank you, Sherry.
Thank you, Mary. I suppose I take over from here.
Yes, thank you.
Yes. So thanks again, Mary, for your very thought-provoking opening. It really sets the stage for today's webinar.
Yeah.
To our audience out there, good day and a very warm welcome to all of you dialed in from around the world and from different time zones for today's webinar. As Mary's put it very aptly, artificial intelligence impacts multiple aspects of humanity, and it's great to stay ahead of the latest developments in this area. And today's webinar is focused, however, on a particular topic of the impact of AI-generated content on intellectual property, out of course, so much that we can talk about. So today's webinar will explore the evolving landscape of IP and notably copyright areas in the era of AI, where new solutions are transforming various industries, including yours, no doubt, from all different sectors. Learn about practical concepts linked to brand protection, the cost of protecting your IP rights, unfair protection, legal compliance, and IP and collaborative agreements, and how this can be applied in this age of AI. My name is Daniel Chua. I'm the head of ESG at TradeFlow Capital Management, and I'm honored to be a webinar moderator today, with thanks to Eurocham Singapore for the privilege. So please bear in mind that whilst today's webinar is in progress, you may ask a question in the Q&A function at any time. We'll keep it open during the webinar. And of course, we have limited time only, so do understand only selected questions can be addressed at the end of our presentations. Before hearing from our presenters today, let's get to know our speaker and our panelist. First, we welcome Max Ng, who shall be our keynote speaker today. Max is the Managing Director of Gateway Law Corporation, a boutique regional practice with offices and people in multiple countries in the region. He manages Gateway's Singapore offices, and his legal expertise includes licensing, franchising, fintech, data protection, and privacy. Max, please share with our audience what you'd like them to know most about yourself and your interest in AI.
Yeah, thank you for that introduction, Daniel. I've been practicing in this area for well over 2 decades now, and certainly AI has been one of the very topical subjects that has now moved from left court to center stage, and I think it's really topical. I hope that I'll be able to share some things that our audience will be able to have some takeaways at the end of the day. So most happy to do that.
Perfect. Thank you, Max. Next, we introduce our panelists, beginning with Jose Lopez, who is the Director for Digital Strategy at TradeFlow Capital Management. Jose, please.
Hi, Daniel, and thank you, Eurocham, for giving us the opportunity to participate here. My role as Director of Digital Strategy of a fund that invests in commodities actually bring value to the investors and take and harvest all the opportunities that technology and AI, among the different uses that you can do of technology, can bring to our trades and how we perform more efficiently. So I'll try to explain and disclose throughout the meeting how we bring value to our investors, how we become more efficient, and how, as being a very small firm that works in a very competitive sector, we managed to survive using extensively AI. Thank you.
Thank you, Jose. We'll hear more from you later, of course. And finally, we have the pleasure of introducing Martin Schweiger. He is an AI expert, patent drafting, an advocate and solicitor, and a keynote speaker, and patent attorney at Schweiger Partners. Martin, please tell us something about yourself.
Daniel, can I share my screen? I put one slide together.
Absolutely.
Okay. Can you see my screen?
I can.
Okay, cool. Here on top is my LinkedIn address. So please, in the audience, please connect me today. I would be very happy to receive that. I give you now the one or more reasons why Shelley has invited me to this talk. So I'm the only one in Singapore in Southeast Asia who's a German, European, and Singapore patent attorney. And I'm a resident and I have a patent firm in Singapore since 2001. I'm a non-resident in Germany, but I have a patent firm there since 1996. I speak fluently German, as you might hear from my accent. I'm a competing weightlifter. I hold 4 national records in Singapore, and I am an Asian champion. I run a personal blog. I've written a book about innovation, and one about that might be interesting, applied AI patent drafting. You find them on Amazon. I give about 12 plus university lectures, courses, and workshops per year in the area of applied AI patent drafting, and I'm teaching patent professionals to generate money by using AI. So I've prosecuted more than 19,000 patent applications since 1996, and I've alone this year trained 72 patent attorneys worldwide in using AI for drafting patent applications. And that is my LinkedIn picture, so you know everything about me. I always go for the victory.
Thank you. Thank you, Martin. So that's a great reminder that we not only have artificial intelligence, but in this webinar, some real intelligence in the house with us today. It's represented by all of our speakers. And with that, we'd like to invite Max, without further ado, to share his keynote presentation on the impact of artificial intelligence, generated content on intellectual property. Max, over to you.
Thank you very much, Daniel. Let me try to do the share screen thing. Are you all able to see it?
Yes.
Great. Okay, good. So today's topic, and well, firstly, thank you to Eurocham and to the SME IP Helpdesk for having me on board to give today's talk and share a little bit about what I know on this subject. And it's, like I mentioned, it's very topical subject. So without further ado, let me move on to the next slide. We can make it work. Yes. Well, I won't go through the introductions once again. That's all about me. It's not as impressive as Martin's. I certainly don't have a power weightlifting photo in there, but I try my best. Yeah. All right. So moving on. I've also been asked to say a few words about the help desk, which Shelley has already covered some of them, but I guess I could just add on to say that the help desk is an initiative of the European Commission, which provides free and confidential advice to small and medium enterprises and intermediaries in the European Union and to all countries of the Single Market Program. Right. On next slide, you will see that there's an inquiry helpline, which you can send any IP questions to the help desk through. Help desk also organizes monthly trainings, workshops, live webinars, which are tailored to the needs of SMEs. So please feel free to subscribe to its newsletter and connect with the team on social media. so that you'll stay updated on the upcoming activities. The Helpdesk website also gives you access to a free range of publications. They have very many country fact sheets, which are, in point form, but very informative, covering each of the countries in Southeast Asia. They're very useful, I know, because we've provided some of this content ourselves to the Helpdesk, and they can be found on the Helpdesk's website. And last but not least, the Helpdesk also offers some interactive learning tools, some e-learning modules, which are available for download from the website. If you're curious about the benefits of IP for your business, so please do go ahead, schedule online meetings with the IP business advisors of the Helpdesk to learn more about how to protect and enforce your IP rights in Southeast Asia. And the consultation is 100% free of charge for EU SMEs, and you can book it very easily through the link you see on the slide. Okay. So without further ado, let me move on next to the topic for today, which is a discussion about IP, copyright, Gen AI. And within this scope, we will discuss in particular the issues of ownership of AI-generated content, and also issues surrounding potential infringement by such content, and also a fair use defense that might be available. And I'll then conclude the talk. All right. So, introductions. Now, I think that most of us are aware of what IP is all about. And most of us on this talk, they are basically creations of the mind. So they can be artistic works, they can be inventions, can be designs, brand names, and so forth. And these are some of the commonly encountered forms of intellectual property that most of us will come across. And I think, as Mary has pointed out earlier in her introduction. So as mentioned, copyright will be the main focus of this presentation, because it seems to be particularly important when and where we discuss AI-generated works. So AI, what does it do? It processes vast archives of text and images. It identifies patterns and relationships. It then establishes rules, and it makes certain predictions, and it is intended to respond to prompts. So I've been asked to define what AI is as well, which is, as we all know, it stands for artificial intelligence. Of course, some of us are also now making a play on the word AI. Apple recently came up with its own version, which is called Apple Intelligence AI as well. But what is it? So one person has defined it as a branch of science in which computers would then produce content which would resemble that of a human. In other words, we have programmed machines to basically respond as if they were intelligent, as if they were sentient. And how do they do this? They do this based on their ability to analyze large quantities of data and to provide an output that would resemble what a human would be able to provide. I think the good news is that, while AI is making leaps and bounds, with the increase in speed of computer processing, it is not yet at a stage where it can replace us, thankfully. So, as the AI mechanism does all the things that it would do, of course, these issues relating to copyright would arise, questions relating to infringement, right? As it processes these vast archives of text and images and identifies patterns and relationships, the question would arise as to whether it does it infringe copyright in the process of doing so, right? As it establishes these rules and makes predictions and responds to the prompts that we give it, does it create copyright material? Does it own this material, right? And which part of it can be covered by the defense of fair use? Now, in preparing for this talk, I actually went to ChatGPT and I asked it asked it a joke. I said, tell me a joke about a copyright lawyer. And this is what ChatGPT replied, right? He said, why did the copyright lawyer go to the beach? Answer, to catch some waves and to make sure that they were properly licensed. Now, ChatGPT seems to think that copyright lawyers are often involved in licensing and therefore uses this term, you know, in its punchline. But you have to say, I mean, as jokes go, it falls a little flat, doesn't it? It's not what we quite as good as what we would hope it could be when you tell it to tell you a joke about a copyright lawyer. This answer from ChatGPT reminds me a little bit about what a 5-year-old might tell me if I were to ask it to tell me a joke. But to be fair, jokes are rather difficult things to come up with, even for humans. And ChatGPT does perform quite admirably for a machine, if I may say so myself. So, forms of, tools available on the marketplace today. ChatGPT, of course, being one of the more famous ones. I think it was said that in January this year, it was the most used, fastest growing app in the AI space, ever. But it's not just ChatGPT that we have available to us today. There's so many others. There's Microsoft Copilot. In terms of text to image, Gen AI products, you have Midjourney, Stable Diffusion, and so forth, where you could, ask it to produce images for you and, come up with things that you could then perhaps might want to post online. I think we've all seen examples of that in postings made by third parties today. So the uses of Gen AI content are so many, right? I think that to sales and marketing departments, it could be a real boon. No longer would the sales and marketing person have to come up with witty lines, dialogue, or content. They could very easily go to any of these Gen AI tools to come up with something for them. Similarly, for customer service personnel, customer service department of many companies, I think many of us have experienced chatbots, taking our questions these days instead of humans. And, to some extent, chatbots are able to perform what they, based on a preconceived script. But I think that with the development and evolution of AI, they are becoming increasingly more and more real, right? And they could take the function of many humans that have been doing it all this while. In the arts and entertainment spaces as well, I think we would see that the use of Gen AI tools have become more and more prevalent. Not too long ago, there was a strike in the US by the Screen Actors Guild because, more and more production companies and the studios have been turning perhaps to robot writers, taking away the job from, humans who used to be able to command these jobs for a reasonable fee. So in so much as these Gen AI tools have been a boon to us, saving us a lot of time, they have also brought with it challenges, I think, that many of us face as we now have to navigate, the output from these Gen AI products. What about in other areas? AI is also found in the field of, for example, patents and designs. I've read that some pharmaceutical compounds and manufacturing process these days may now be created or assisted by Gen AI as well. But I guess from an IP perspective, the courts have held that in order to get a patent for some of these novel products that may be churned out by Gen AI or assisted by Gen AI, a human intervention, humans element must still be involved. So words used are that a human must make significant contributions in the process to get a patent, right, for such Gen AI products. But no doubt this is going to be Martin's area, and he's going to be talking about this later on in terms of drafting of patents and so forth. I'll leave that for Martin to talk about in more detail in a while. However, I just want to say at this point in time that attempts have been made in this space, in the patent space, for AI to come to the fore. One such person, as some of you might have known and heard, would be a scientist and an inventor by the name of Stephen Thaler, who tried some years ago to apply for patents, but he would not put the name of a human person as an inventor of the patents. He applied for it as an applicant, but as the inventor, in place of the inventor, he would put in the name of the AI system which he had developed, DABUS, D-A-B-U-S, which I think most of you would have heard about DABUS. Also stands for Device for the Autonomous Bootstrapping of Unified Sentience. So he has tried very hard, not just in the US, but in other jurisdictions as well, to insert DABUS as the inventor of these patents, of these inventions that he has applied for. And unfortunately, or fortunately, depending on how you look at it, the USPTO did not accept his argument, did not accept his application, and said that only natural persons can be considered to be inventors. Similarly, the Eastern District of Virginia agreed with the USPTO, and we tried to appeal to the Federal Circuit. Federal Circuit similarly upheld the decision. So in August 5th, 2022, the Federal Circuit in the US affirmed and found that the Patent Act requires an inventor to be a natural person. And so the legal challenge for now has stopped at that point in time. But who knows, right, how the law will develop as AIs like DABUS becomes more and more sentient, shall we say. Anyway, moving on, ownership of Gen AI content, right? So from the perspective of the Singapore courts, because I'm a Singapore lawyer, so I tend to look at the decisions. The Singapore Court of Appeal has made it quite abundantly clear that in order for there to be copyrighted work, there must be a human author or human authors, right? So that part is quite clear. It said that, you know, a human person must first be identified before the work in question can be deemed to be original. And it has said that without the identification of a human author from whom the work originates, there can be no original work that's capable of copyright protection. So the court elaborated that in granting, if you were to do otherwise, you might end up granting copyright protection in perpetuity to a machine, right? For example, something not human, which goes against the public policy, because at the end of the day, copyright law exists to protect the efforts and endeavors of humans. That is encapsulated in the Copyright Act in various schemes. It's sort of implied. There's no specific express provision in the Act that says that the author has to be a human person, but it's more or less implied. For example, duration of protection is that of the author's life plus 70 years, right? That will not stand if the author never dies, right? Yes. So that's the second case on this slide. The first that was back in 2011, and then it was subsequently reaffirmed in a more recent case of Global Yellow Pages and Pro Media Directories, where the Singapore Court of Appeal again said that for copyright to subsist in any literary work, there must be an authorial creation. That means something created by an author of the work that is causally connected with the engagement of the human intellect. And by human intellect, we mean the application of intellectual effort, creativity, or the exercise of mental labor, skill, or judgment. So I guess the good news for all of us is that at the end of the day, the courts have been quite firm against the notion that a non-human can own IP rights. Yeah. So this approach, whereby human authorship is required, is of course consistently, we have seen so far, consistently the case in other jurisdictions as well. Again, in the US case that we see here, Thaler versus Perlmutter. So this is the same Stephen Thaler that was involved in the Dabus cases. In this case, he was now then attempting to register copyright for an image created by Gen AI. So obviously you can see that Dr. Stephen Thaler is a real big proponent of AI. And he's from this school of thought that believes that AI should be granted IP rights as well. However, the US Copyright Office did not agree with him and refused registration due to a lack of human authorship in this case. Again, the judge upheld that Copyright Office's decision on appeal and stated that an original work of authorship requires that the author must be a human. So this degree of human intellect is very important in terms of copyright protection. And you can see it in the US cases, in the UK cases, and even in China. All right, case cited here is Li Yunkai versus Liu Yuanchen, where the Beijing Internet Court, China's quite advanced, they have an internet court, they have a specific internet court. But basically it held that in this case, there was a human person behind the Gen AI system, and it was making creative decisions, which was sufficient to prove human authorship in that case. And therefore the claim for copyright infringement in this case was allowed in China as well. So a review of all these cases would show that it's quite evident that even if courts around the world may not agree exactly on who owns the content that's created by Gen AI programs, the general approach does consistently seem to fall back on general copyright principles, which is that there must be an exercise of human intellect and that there must be human authorship. So although Gen AI may increase our workplace productivity for sure, but for it to enjoy copyright protection, there must be the sufficient exercise of human intellect in the creation of such works. And that must be documented as well. Okay, so here we have a diagram of possible owners of an AI, for a Gen AI created work, right? So on the one hand, we have humans, and on the other hand, the AI itself. So cases have consistently held that no, the AI itself is not going to get copyright ownership. Yeah, no court has been willing to grant it so far. But even when we look at the human aspect of these works, there are perhaps sometimes different humans involved in this, right? It could be the programmer. Would the programmer of the AI, programmers behind ChatGPT, for example, would they be the humans that are entitled to ownership of the copyrighted work? Or would it be the owner of the AI platform, right? So if someone came along and bought up ChatGPT, would that person be the owner of the copyrighted work? Or would it be the users or the persons who are using the AI tool that would then be the owners of the copyrighted work? Right? So in terms of humans, there are still humans from very, many different categories involved in the whole scheme that could possibly be the owner of a work. Yeah. That brings us next to the next topic, which we're going to talk about, which is potential infringement of Gen AI content, right? Okay. So in this respect, we want to look at two aspects of the process. The machine learning input stage of the process, where the AI is being fed and is trawling through tons and tons of data and materials in order to be able to produce the output later on. And then on the other side of the slides, we have the machine-generated output, right? So would the first part of it, where the AI or the machine is trawling through all this data, would that be an infringement at that stage itself? And then subsequently, when the output is generated by that AI system, would that work be sufficiently transformative? Would it still be a derivative work of the originally infringing work, such that it in itself is still an infringing work? I think these are the questions that we would like to find greater clarity on as the cases go. So there are some examples that are given here of different types of projects that are ongoing and using certain AI tools like Midjourney and Stable Diffusion. In the case that I've cited on this slide, we have an example of Getty Images. So Getty Images is a repository of copyrighted images, as I think some of us might know. If we wanted to find an image that would be useful for our marketing purposes, I think most people in the marketing space would know that, Getty Images is one of the places we can go to buy the use of an image, to take a copyright license from them, to use an image for a particular purpose, slide on your website or your PowerPoints and so on. But with the advent of tools such as Stability AI, for example, you might just go directly to Stability AI and tell it, hey, AI, I want to have a picture of myself flying a rocket into space, and then it might just create one for you, right? So the question then would be whether or not Stability AI, in undertaking that task, is it infringing the IP of copyright owners, such as those that, for example, belong to Getty Images, right? So Getty Images alleges in this case that Stability AI has been scraping its images from its websites, which it then uses to train and to develop Stable Diffusion, which is without its consent, and therefore the improper use of its photos and its images violates both the copyright and trademark rights in its watermarked photograph collection. So what is interesting for us now is to follow these cases as they go through the courts. There are other cases as well, of course. The one cited in this slide is Anderson, also against Stability AI, and this is also in the US, right? In this case, artists have formed a class action lawsuit to sue the Gen AI platform as well, because what these AI tools do is that they need content to train these AI models on. And, they just take whatever is available on the internet and they do so, right, without a license. So all these cases are very interesting to follow. We don't yet have such cases in Singapore going through our courts, but it is hoped that in time to come, there will be some of these cases as well, which will then give us guidance on whether or not the copyright owners would succeed in alleging infringement against these AI platforms. These AI platforms would sometimes, of course, no doubt, assert the defense of fair use. Some of us users will assert the defense of fair use. And the defense of fair use is found in many jurisdictions with some variations. This is what we have in Singapore, and I think similar to what there is in the US as well. Generally, in assessing whether or not the defense of fair use is available, you would have to look at the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work, and the effect of such use upon the potential market for or value of the copyrighted work. So these are factors which would help you to argue that, hey, I'm just using it for example, for my school project, right? So that's fair use, shouldn't be the subject of a copyright infringement lawsuit. Yeah. There are other cases, of course, where again, the defense of fair use was brought up. In this case, Warner Brothers Entertainment versus RDR Books. RDR Books intended to publish an encyclopedia on the Harry Potter series. And the court in that case, however, held that the text that they had inputted was only minimally transformative, since many of the entries still contain verbatim language from the Harry Potter books. And therefore, in this case, court said, no, the defense of fair use did not apply to them. So there will be then copyright infringement. Yes. So we would therefore have to consider how chatbots, how ChatGPT and such tools may compile and disseminate facts that are found in the public domain. And, if it's educational in nature, perhaps we would be able to argue that you should find fair use in this case. But if they're using these tools for commercial purposes, then this would probably weigh against a finding of fair use, right? In Singapore, we have also certain exceptions like the computational data analysis exception, which is an exception under the Singapore Copyright Act, basically to allow for persons who are just simply analyzing data, right? So you may otherwise be said to be infringing because you are copying code and analyzing that code. But if it's just for that purpose alone, this defense would apply to you and say that it's a lawful access. So I think at the end of the day, all of us have to pay great attention to how Gen AI is being used. And we also have to pay particular attention to the terms of use when using it, and to take note whether the training inputs used in each of these platforms, are they using copyrighted works, or are they using works that are in the public domain? If so, then it's much safer, right? So you got to look at the inputs and look at what the training models that are being used for some of these AI tools, look at what they cover, what they don't cover, and then from there, one would be the better place to make a determination over whether or not you might actually have acquired rights or not in such Gen AI model training output. In the interest of time, there's a lot to be said in this area, and this is just covering the tip of the iceberg. But what I do hope is that some of us will have some takeaways from today's session in terms of knowing that insofar as authorship and ownership of such output is created, the law seems to be fairly settled in the sense that it is only humans who would have copyright ownership over such materials. The AI platforms themselves cannot have copyright ownership, and so cannot assert it against anyone else. But in the space of infringement, the laws are not as well settled yet, and so we have to watch this space and see how it develops in order to determine at the end of the day whether users are said to be infringing or not. Yeah. So just to end, perhaps I'd like to go through the terms of use as provided by OpenAI, which includes things like ChatGPT. And it does say, contractually at least, as between you and OpenAI, and to the extent permitted by applicable law, you retain your ownership rights in the input, and B, you own the output. And we hereby assign to you all our rights, title, and interest, if any, in and to the output, right? So in that sense, as far as it's between you and OpenAI, it seems to be the case where they are ceding over all copyright ownership to you, which, of course, the position is subject to change because, as we all know, once upon a time, we were happily using Instagram, and one fine day, Instagram changes its terms and conditions and says that everything that we put on Instagram now belongs to them, and all copyright belongs to them instead, right? But by that time, you're already hooked, right? You can't change anymore. So with that, a little bit of food for thought for everybody, and I'll turn the floor back over to you, Daniel. Thank you.
Thanks very much, Max.
Yeah.
Thank you indeed. Yeah, lots to think about, lots perhaps even to worry about. But it's good to know that at present, the human is still protected. It's good to know also that AI can be trained to pick up intellectual property infringements, especially where there's public domain usage, for example, music. What struck me was that AI could be biased, right? As it's based on databases ultimately and programmed by humans that may be biased. Transmission errors can exist, therefore. And therefore, the whole construct ultimately is still built, I suppose, around humans. And that's, of course, perhaps a more philosophical question. And these were thoughts that occurred to me anyway. And with that, I would like to invite our fellow panelists, Jose and Martin, to come onto our virtual stage. And just like, you know, Max's presentation raised some thoughts on this end, I would like to hear from you what stood out to you about Max's presentation. Jose, would you like to start?
Sure. By all means. Well, thanks, Max. I think it was very, very clear, the presentation, and he brought a lot of lights to some concerns that I personally had. One of them was who is the when Gen AI, what you were mentioning in your conclusion point too, right? If you create something, that is, you've been generating artificial intelligence in order to create a product, whether that product is, I'm actually bringing it to my domain. So in finance, if you're using generation AI in order to bring many variables or huge numbers, and you get to an outcome, and that outcome, some sort of, you create either a program or an algorithm that brings you to results, right? In which part that algorithm that you have created is truly yours, and the conclusions or the outcome is truly yours, right? And you're mentioning that if it's heavily using databases that are not yours, you might be infringing that. So for me, that was very clarifying, Daniel. Going to your point, I think it's a fine line. I think each judge would have different views. I do agree with Max, of course, as an expert, that you have to take in consideration the origin of the databases and the origins of the data, disregard as you're working on the algorithm. So I think in the future, there's going to be a lot of this, a lot of byproducts generated by Gen AI that would have a lot of different parents, let's call it that way.
Thanks, Jose. Thanks, Jose. More food for thought you have raised, in fact. But now let's hear from Martin, whilst I suppose Max generates thoughts in response. Martin, over to you.
Now I'm unmuted. Can you hear me?
Yes.
Okay. Yeah, I know Max for a very long time. We go for lunch quite often. So Max is clearly a lawyer. And while I'm not a lawyer, I'm a patent attorney. And in 28 years of my practice, I had about 5 copyright cases as compared with 19,000 patent cases and maybe 5,000 trademark cases. So I find those discussions about who owns what AI does a bit, how to say, not so relevant for us patent attorneys. We And that comes because copyright is one form of unregistered intellectual property. We have registered IP and unregistered IP. And when a patent attorney speaks about IP, we always talk about the registered one. And when you register it, then only would the patent office or a court question ownership if there's a reason to do so. And in the Dabus case, there's this, I mean, I would even call him a lunatic, this guy who wrote deliberately that his robot did all the inventions, while that would be comparable to an engineer who files a patent for something and then he would say, and the inventor was my sharp pocket calculator, right? So, and then of course, if you write a pocket calculator as inventor, then of course the poor bureaucrat at the other side at the patent office cannot give you a patent because he needs to have a name. So he would ask back, does your calculator have a first name at least? And but it doesn't. So this was clearly done to provoke reaction, and that comes from those people that are in the religious corner. They believe that AI at one point in time will become so powerful that it takes over the whole world. And sorry, I don't follow there. For me, AI will always be limited to what the machine can do, and it doesn't come with wisdom. And that wisdom is what makes the difference between a computer and a human, and that will remain like that for eternity. I can tell you because I work with AI since age 21, which is now almost 39 years ago. So I really don't think that this is a good way to discuss AI. I believe you should rather look into what AI can do. And one fact is that AI makes the right people in average twice as fast with better outcome, more precision and less mistakes.
Thank you, Martin. We are reminded, however, that the entire existence of life itself on Earth is but a blink of an eye in the evolution of the cosmos. So when you say for all eternity, perhaps in 5 years or 10 years, you may wish to re-evaluate that.
But I'm very clear, right? The guys who say that AI will take over the whole world come from a religious corner. And I come from also not from a religious, but from a corner of a believer. I'm a child of God, and I believe that this was not created to take over the whole world. It's just the same degree of faith that I put into that statement. So I know I will not revert that in 10 years from now.
Okay. Well, we might just check back just in case.
Nice.
Yes. However, you know, I'm reminded that not so long ago, lots of people viewed the invention of computers as a threat, and now we are using computers in so many forms, even the fridge as a computer. And now, while some people are worried about what AI can do, well, I dare say personally, the prediction is that over time, I can't say how long, 10 years, 15 years, it will soon become so much a part of life. It's again, it becomes something so much in the background, you know, that we don't even need to talk about it like we're talking about it today. However, the danger exists, of course, in the world of business about rights and attributions, especially where there's money concerned. And I suppose there will always be work for lawyers, no doubt, who would be using AI to support them in their work. Max, what is your take? I mean, how has AI helped you in your work, for example, in supporting cases?
I think it's still early days, but I think AI has been very useful in and it could, well, not just maybe AI, but also generative AI. I think that generative AI is the hot topic today because you know, AI has existed for many years in various shapes and form. And one example of AI which I hope will be sufficiently robust in the near future will be that of autonomous driving, because you know I don't like to drive. So if there's an autonomously driverless car that would, yes, indeed, Martin, if there's a car that could drive itself, I would just love it. You know, that would really make my day and maybe make my decade as well if that came to be. So that's one form of AI that we hope will come to pass. But in terms of generative AI, I suppose at the end of the day, it's a question of the integrity of the end product that is the issue right now. I mean, it can do many things, but to use the example I gave, tell me a joke, was it good enough for use for public consumption? I don't know, right? So that was just a simple example. But if I wanted to use, and there have been cases as well of lawyers who have relied on AI to produce legal submissions, and AI has produced certain cases which, when checked, were found to not exist actually at all. It created, cited cases which seem very real, but actually were totally fabricated, and is the problem of hallucinations, which would be covered by. Talk about AI, we talk about its ability to hallucinate as well, to create facts which are not really facts. So those are the things that remain in the use of AI. So that's why we all have to be very careful. Singapore, the courts, and I think many agencies are coming up with guidelines on the ethical use of AI. And also in terms of creating an AI framework, Singapore now has an AI framework as well with 12 points to consider when using AI. I think these are all things that are moving targets, so to speak. And when it gets to a situation where I think AI is sufficiently robust, that's when we will see greater and greater use of AI in our daily work. Yeah.
Thanks, Max. Yeah, I must confess I didn't quite understand that joke generated by AI. Maybe I'm not smart enough. But in regards to application, okay, so you raised a very good case study to talk about. I mean, in the future, if there were driverless cars, and it was so simple for a company to say, hey, AI, write me code that can drive the car for me. And we've got 10 different companies all using AI to generate code that's been pulled from somewhere. And how do you then differentiate the IP? What if one company says, oh, I want to sue my competitor because this code is similar to mine? I mean, I'm just using this as a very real potentiality, right? So in cases like that, how would you judge who wins, who loses, who can continue using the code?
Yeah, I think that brings us to the issue of copyright infringement, which then it's going to be so difficult. I think that when this case comes to a court, it's just going to be so difficult for the judge to, I mean, we are handling several copyright software infringement cases ourselves right now. And there always has to be a software or IT expert who's involved in the case. And the poor IT experts will have to trawl through a gazillion lines of software code to somehow make a determination or a finding as to whether there is substantial copying or not substantial copying, and where is the copying, and was it essential or not essential. It's really complex kind of case to be brought before the court. So I'm afraid there's no easy answer, right? You can't just say like, okay, he's copied 15 lines of code, but he didn't copy 10 lines of code there, so it's not a copy, or it's always going to be a situation, I think, for the party, for the claimant, the one who brings the case before the court, it's always going to be his case to prove that the other company, whether using AI or not using AI, copied his code, right? That's always going to be a big challenge, I think.
There'll still always be a role for good lawyers, therefore. I have to raise at this point that the work of the World Intellectual Property Organization, I suppose, is important in this regards, and that it is actually headed, if I'm not wrong, by a Singaporean as the Director General. Is that right, Max?
That's right. That's right. Exactly right. A good friend of mine, Darren Tang, he has been helming this role quite admirably and putting Singapore on front and center in the world of IP. Yeah, that's right.
Well, he's got his work cut out for him, given the complexities you've raised. Yeah. So speaking of raising to our panelists, I've got a question from our audience. It's from Gregory. So his question says, considering the increasing sophistication of generative models, how should IP frameworks address cases where generated content is sufficiently similar to copyrighted works, but not an exact copy? So you've alluded to that so far somehow. But his other question is there a threshold that can be set by somebody for similarity, like you know, a 90% match? It's just like in paternity suits or in criminal cases, right? The DNA has a certain match, then you know, you are there. You are the perpetrator, right? If the DNA is such a close match. Who bears responsibility? You know, the user, the platform, or the creator of the original work? Yeah, some quick thoughts there before we move on.
Max, yeah.
Yeah, please go ahead. Yeah.
No, I'm saying, Max, that's entirely for you as the expert.
Okay, all right, Jose. I think that this is again very similar to the previous question you asked, which is, you know, how will I know whether a work is sufficiently similar such that it's falls within the realm of copyright infringement or not? And I don't think that any court has ever laid down a hard and fast rule to say that, look, 10% is fine, 20%, 11% is not fine, that kind of thing. I think it's always been on a case-by-case basis. And so that makes it very interesting for IP lawyers to argue in court, to be able to argue whether something is so similar or not, right? Yeah.
Okay, so from something very specific to I suppose something a little broader, but the next question is addressed to Jose. Has the implementation of AI modified the existing intellectual property related to commodity trade finance as a whole?
Yeah.
Experience there?
Of course, no, I can speak from our experience in I think this actually extends to the market, right? So very briefly for the people to understand, we are a commodity trading fund. So we buy and sell commodities and we make a profit in the process. We're very small. We've been working with AI from the very, very beginning. Typically, trade finance and particularly commodity trade finance has a lot of paper involved. You have the letters of credit, you have the certificates of origin, bill of ladings, and you multiply that by endless number of trades. So it's huge amounts of data. That data is still mostly in paper. So we use large language models to actually extract the data that we want. How many kilos, what is the price, what is the delivery port. So you train models for that, right? And we've been training our own model, so it has an impact. We have, if you create a model and once the model reaches around 93% success ratio, we consider it's very much valid, and it reaches a human eye or the human factor. So we can use, what we do is we empower our back office to do something else that brings much more value, right? Just focusing that the model is working and checking the information that we want. So to your question, does it impact trade finance? Yes. I just gave you an example on something very basic and already old-fashioned AI, which is the language models and how to extract information. There's something more attractive that we do now, which is predictive analysis. So we are, as I said, in commodity trading. So the vessels go from port A to port B. When you're charged by the time that you're going to arrive to the port and the time that you're going to have loading or unloading your cargo. So typically, Port of Singapore, to give an example, would say, we'll wait for you Friday at 5 p.m. and you're coming from Japan. There's storms, there's different conditions, weather, different traffic, and so on. So you have predictive analysis. If you give all the data from satellites, from cargoes, from the port, to adjust the speed of the boat to arrive Friday at the time that Port of Singapore has told you to arrive. You burn less fuel, so it's cheaper for you. By the way, if you arrive late, you have to pay a penalty or a fee. So that predictive analysis is also used in the world of trade finance. It's fairly common. It's called the demo rush cost, and that's in our day-to-day.
Thanks, Jose. That was in gist, I suppose, how the world of trade finance works, and the good work TradeFlow does in moving commodities from different parts of the world, to support SMEs in particular. So I want to dive a little deeper into that. In terms of intellectual property usage in commodity trade finance, what are some of the trends that we see in this particular industry? And is there anything that we could say is a best practice that other industries could be adopting?
So most of the companies are relying heavily in software as a service. So when you have, for example, in our case, 300 trades a day, that means 300 different vessels and some port in the world. You don't have 300 people checking on each vessel. No, you need an automated system that tells you exactly where's your vessel, what is the cargo, what is the status, how much have you paid for that, have you issued the invoice, do you have all the documentation, has all the documentation arrived to the port, and so on. So there's many variables. That software as a service is called CTRM, Commodity Trade Risk and Management System, that of course uses AI and involves all these predictive analysis, extracting documentation, and so on. Sometimes you automate invoicing directly to your bank. And by the way, you need to leave an audit trail to do your audit accounts. So your accountant is going to say, give me proof of all of this, right? And you need to have an audit trail. So most of the firms, they actually use or rely on CTRMs. At TradeFlow, we have our own CTRM, which we created from scratch, and we're very proud of it. And you always have little tweaks to adjust every time as the AI develops and it goes faster and with better accuracy.
Thank you, Jose. Okay, I'd like to turn the spotlight now on our heavy lifter in the room. That's Martin, obviously. So a recurring theme when using AI tools is data security and potential IT issues. So what are the key security risks associated with using AI in data drafting?
We can talk about that. But what do you think? Shouldn't we just show how AI drafts a pattern from scratch within 5 minutes?
Why not?
Okay, I share screen, huh? I mean,
Yes.
I understood that we have enough time for that, right?
We do.
Okay.
On our audience, the maximum,
Yeah. I mean, what I see is in my many trainings that I've done so far and workshop, and so you need to generate a jaw-dropping moment at one point in time when you show the benefits of AI. And also participants would need to understand that AI can only do 50% of the work. So you have to walk the last mile yourself. I have shared here my personal blog here, iplawyertools.com. And there's I can put that one in that article into the chat, and maybe I do that. And I write a lot about AI, and you can read up, and there's even a free course for so and so what I have here an example of a circuit, electrical circuit. For all the non-engineers here, this is an oscillator, one of many designs, is already 120 years old. But let's assume that this was an invention. Right? And then you go here to this is my own GPT. I have trained this one and written. And then what I do is I zoom in, and you would see here, this Schweiger and Partners is my firm. Workspace chats aren't used to train our models. And that's a part of the answer to your question, because there are so many different AI bots out there. And there are some that are secure and others are not. And I don't understand why we always discuss about security when we don't select the highest standard AI bots there, right? So this is one that costs $25 a month. And what I do is I copy paste the screenshot of that circuit there, and I give the prompt, write a pattern application for that circuit diagram with claims and figure description. I press here and off it goes. And you would get the pattern application that is not bad, I would say, is enough as a provisional to secure a priority right. And it's a bit slow now because Europe is already awake. And it doesn't want that. Okay, describe that figure. So prompting is a difficult thing, and it would start here.
Okay. Oh, processing failed. So Martin, this raises thoughts. You know, Albert Einstein used to be a patent clerk, and we all know he obviously was a
yeah. So it seems somehow that this doesn't work. I have another one. I don't know why. Usually it works here, and then let's do this one. Write the patent application or invention disclosure for that figure. I've done that often before, so I'm a bit surprised that this is not.
Whilst it's generating, has the system ever told you that the patent, for example, you're trying to file has an infringement?
You can check. See, now it starts writing. You can use the AI, the system that I have here, to check whether a certain embodiment or a certain product would infringe a patent claim, for example. And you see, this is quite complete. It's a resonance circuit. Yes, you can check infringements. And as I said before, if you train people to use these LMMs, then the speed of a normal patent attorney would double with only 1.5 or 3 hours training time. And you see here, it talks about competitive advantage and so on and so on. So if you ask more prompts, then this would give you a very decent description of something you have only a figure description. But now to your, I hope this was a bit jaw-dropping. And now back to your questions about security. I've trained more than 72 patent attorneys alone in 2024. And that also means that I talked with another 72 patent attorneys who investigated whether the training would something for them. And I always hear the same 4 fears, I would say, is data security, data security. The first one is always about, will that data be stolen by the owners of the language model? Because I work here with a software as a service, and the answer is, sometimes, yes, the data that you put in will be either be the property of the one who runs the machine, or it would be published, or both. But there are others that are paid, and those paid ones usually secure your rights as far as the ownership is concerned. So that first fear can be addressed by just selecting the right robot, and we would show you which one to use, right? The second fear is that by posting your invention into such a robot, would you generate prior art? That means, is it published? And if you don't file on the same day, would that destroy patentability because you have disclosed it in public? And the answer is no, it's not. In most cases, you need to be careful and choose the right robot. The third fear is, would my data that I put in be used for training, and so it would show up in someone else's patent application unintentionally in the future? And the answer is, choose the right robot, and no, it will not, right? And I can help you to choose the right one. I know all 35 tools. Every other month there's a new one, and some are safe, others are not. And the fourth is one for us lawyers, Max and I, because if we disclose secrets of our clients to a third party, that is something that is valid in Singapore, at least valid a jail sentence, right? So not so in Germany, but you would lose your practitioner's license if it comes out that you reveal clients' secrets and so to the public. And again, it comes down, is it intentional or is it because of negligence? And that can be done if you do a proper due diligence before you start using the robot. And these 4 points cover 99.9999999% of the data protection concerns. And I would say if you address that hairy monster of data security, then you would find that there are ways to make sure that there is a data security.
Thank you, Martin. You reminded me of a song, 99 Luftballons.
Yes.
Famous
yeah.
song, that one. Yeah, I don't know why it just popped into my mind when you said 99.9.
Yes.
But actually what you just mentioned is very important and critical to the work that Jose does, is actually risk management, choosing the right bot, the right service,
Yes.
But again, I disclaim that Max earlier himself said that terms and conditions can change at the push of a button. So, it's hard to predict in future who buys a company and then decides to do what they want with it. Lots of examples there, actually. But yes, risk management, I think, has to be applied into the application of also AI in the world of intellectual property. Max, any thoughts there?
I think that's very pertinent and very relevant as well. And that's why it's not just a simple tool of just choosing to use ChatGPT or whichever version you feel like. As Martin says, there's so many new tools coming onto the market every day, every other day. And that's where I guess you have to use someone who has the knowledge and the expertise as to which are the appropriate tools to use, considering your background, your risk profile as well, and what are you using it for.
Yeah.
So it's a lot of work that needs to go into it as well, especially if you're using AI for enterprise work or commercial work. I guess if you're using it for your school project at home, maybe not so much to worry about. Yeah.
Yeah, I mean, what I identified over the long time that I do this now, there are mainly two technical areas that are very sensitive to data theft, and this defense industry and pharmaceuticals with the research data. So these two really, but they know that, and they started to install the AI models on premise with no connection to the internet. And then there you go. I mean, it's a risk assessment, and you take the necessary measures from that, and then you must make sure that it's safe. Yeah.
In fact, this recalls a development 2 days ago that global bodies have decided that AI can't be used to decide on nuclear war.
Really?
So it's still in the hands of humans. Thank God for that, personally.
Yeah.
So,
but they would get support,
Yeah.
Daniel. They would get support. I mean, the military would. I mean, the military. I know because I was in that area. Lives from intelligence, right? And you have fragmented data, and of course, would they use AI to build a complete picture of what is going on in the battlefield or of course would they use AI, but ultimately a human has to make the decision, right?
Oh, we hope so. That's why what Max mentioned earlier, and you mentioned it too. The human and machine interface has to work together well, right? It has to be in balance. It's a check and a balance, because if it's overly skewed in one direction, I think that's where things could go wrong. And you mentioned very saliently, both gentlemen, that depends on the risk of the situation. So if there are more risk, I suppose you need more checks and measures. More more watchers of what is going on. We've got an easy question next from Felix Cotman. After this discussion, his question is, if he uses generative AI to solve some coding problems, to write functions, can he use this in his other code? Basically, build code using code he's found. Anyone wants to take this?
Yeah,
X sits in your lap.
I could give it a go as well. I think that it's closely aligned to say using open source software to develop code and so on. I think, well, firstly, as an aside, a lot of people think that open source software is basically free to use with no conditions, no strings attached to it whatsoever, and they can do whatever they want with it once they've used it. But actually, that's not the case, because even open source software comes with certain terms and conditions attached to its use. And then depending on the level of how free is the freeware, so to speak. But coming back to our point, again, if for example you're using a tool like ChatGPT, as mentioned earlier on, it said that whatever we generate is yours. So if it's yours, then in theory you can then use it for your next project. But of course, the answer unfortunately doesn't just end there, because if at the end of the day, what it's generated for you draws from copyrighted proprietary work, it basically, in this case, is an example of computer code. But in the example I gave earlier about Getty images, I think it's easier to understand when it's an image. Pictorially, I think we can identify with it much easier. So, someone probably went to Stability AI in the case and said, please, can you just generate me a picture of myself and Taylor Swift performing in a sold-out concert in Singapore, right? And then it would probably come up with something and put you there and Taylor Swift. So it comes into the realm of deep fake, right? So even, and then the question would be, how did it get that image in the first place of Taylor Swift to be able to generate this image? Did it scrape and take the materials from certain other copyrighted sources? And just, because the internet has basically just made it so easy to copy anything and everything that's out there that's digital. So if you took from copyrighted materials, whether it's Getty Images materials, or you took it from proprietary software that belongs to Microsoft or whoever it is, and then used it to generate code for you, and even though the AI platform says, well, I've generated it for you, now it's yours, you might still be sued at the end of the day by someone else who says, well, whatever you're not producing and putting out there has got my proprietary rights in it, right? Whether it's a software code, or Taylor Swift might come along and say, hey, you can't just produce a picture of me with you in it. I'm surely got some copyright claim to that as well.
Mm-hmm. Yes. So to sum it up, Felix, it seems that process, application, and also very importantly, intention must be considered, right, in the use of AI in this case. So you have the intention to defraud, then you might also get into trouble, right? And it's proven so. And related to that, I mean, the use of AI makes creating content so easy. I suppose end of the day, it's about what's worth protecting, right? So this brings to mind Scarlett Johansson. You mentioned Taylor Swift. So this example popped to mind. I think she successfully won an injunction against Google for a bot that sounds like her. Yeah.
She did. They copied her pitch, and they used it without her acknowledgement, and yeah, she actually won. I mean, you can discuss whether that was the right or the wrong approach, but the intention was to make use of her public figure because her voice pitch was recognized. Yeah. Recognizable. Yeah. I think, to be fair, since we have very, very little time left, I would like to give the approach. I mean, we're talking about a lot of creation of image, what is important towards the IP, what is important to AI. I think that the moral of the story is that we have an extremely powerful tool to become more efficient, to have access to information that otherwise was not available. So if I wanted to do what was the IP in Canada or in Israel or in Australia, it would take me forever. And now even ChatGPT, that is definitely not the most updated one. So there's services up there that you pay more professional for a business, and they're much more advanced. So I think, as I was saying, the moral of the story is in order to become more efficient, in order to compete in a globalized world with other industries, other companies, other countries, You have to take everything that can give you an edge. I think AI does it. Of course, you need to protect everything that is IP. Despite some countries don't do it, that doesn't mean you're supposed to play by the rules. But I think the conclusion that I would give to the people that is actually looking is not an alternative. It should be something that you should be very comfortable using it, even if it's just to check whether your paper is right or the information that you're extracting actually is true and verifiable, or if there are ways to improve whatever you're doing, from writing a CV to writing a speech to preparing the topic today, or doing your IRS declaration, right? So that's my 2 cents. No, use AI to your advantage. If you leave it on the side, unfortunately, you will be dragging behind.
Thank you, Jose. Yes, indeed, we are running short on time, 2 minutes left to go. And it seems you have preempted my question about, the key takeaway, from each panelist. With 2 minutes left to go, I'll now pass it to Max and Martin each to, leave, your closing thoughts and what our audience here should really bear in mind at the end of this webinar. Max first.
Sure. I think that given the premise here is Moore's law, I think we're all familiar perhaps with Moore's law, where it says that computing power in computers is going to increase exponentially as the years go by. So given that an increasing amount of data that's flowing through our digital systems and advances in technology, I think it's inevitable that we will one day have driverless cars. And in fact, one day we will probably go to the moon as well, and to Mars as well. One day, if Elon keeps doing what he's doing. So we just have to prepare for it, right? It comes with its good points, it comes with its bad points, but we just all have to prepare for its inevitable arrival. That's my message.
Noted. So be prepared. Do it. Martin.
AI only makes sense if you can make money using it, right? And I would say it's very difficult for the normal user to learn how to make money by using AI. So there are trainers out there who help people to cut the learning curve. I'm one of them. So if you want to learn how to use AI in your patent work or also trademark work, then please contact me. I believe... would they know how to contact us? I don't know. Maybe LinkedIn?
I believe so. Yes, you've shared your LinkedIn earlier as well, Martin.
Is it okay? Then I put the link into the chat also. Then anyway, so please let me know over LinkedIn when you need help. That's crucial. And I've seen that many times you help someone 1 hour or 2 or 3, and suddenly they're running and they're twice as fast as before. And that's not something that is unusual. There are people who can triple or quadruple the speed. And I must also say there are also very few, maybe 10%, who don't get faster. They even get slower when they use AI. Yeah. And you need to have a trainer, like as with a sport. If you start something, you're much better off when you have someone who helps you to succeed.
A good coach, right? Bear in mind the right intention, process, and application.
Yes.
And of course, all that comes better with a good coach. Thank you, Martin. So to our audience out there around the world, with these closing insights, have come to the end of our webinar today. And we hope you found this very interesting. And you've got actionable information related to artificial intelligence, generated content, and intellectual property. On behalf of Eurocham Singapore and all our speakers today, Max, Jose, Martin, thank all of you for your participation. And please do stay tuned for upcoming activities by Eurocham Singapore that can help you and your business. With that, take care and farewell.
Thank you. Thank you, Daniel.